So, enjoy. Our first guest speaker this morning is Clair McCarthy. She's a consultant solicitor in the business. For those of you who don't know her, she's my right-hand woman. So she's going to start by talking to you all a little bit about the interview process. So I'll be back later.
Good morning. When Carolyn and I were trying to work out our agenda for today, one of the things that I've noticed over the last year or so, either doing interviews or at the later stage looking at the public inquiry papers, is that DVSA interviews and potentially also police interviews are being done. And it's quite clear from what I'm seeing when I go to see clients, or if I don't see them and I see the transcript, is that actually many clients haven't a clue what they're doing either. And it is my view, and my background was criminal defence work, is that cases are lost and won at the interview stage. And indeed, cases can be stopped at the interview stage because you give a good interview and it ticks all the boxes for the investigating authority. Or you give a good interview and it gets you a better outcome in the end. So I hope that you'll bear with me while I make sure that I turn on the right slide. So that's what I'm going to do. DVSA interviews and then police interviews. I'm going to start with DVSA interviews. So both of them have the caution. I'm talking today about interviews under caution, not when you have a quick chat with the DVSA when it comes down to your when they come to your office. So you've all maybe watched 24 Hours in Police Custody, etc., etc., and you hear the caution said. Essentially, what it's saying is you don't have to say anything, you can stay stum. But the sting in the tail is, if you stay stum, then potentially if you have a defence, in other words, something that will get you out of trouble, and you don't say it at the point of interview, but then you bring it up later, maybe at PI, or you bring it up in criminal proceedings, what can happen is it can harm you. And how it can harm you is that either the traffic commissioner or the court can take the view, hang on buddy, you had a chance to say that back at your interview and you didn't take it. I find you less credible. Yeah. And then obviously the other sting in the tail is whatever you do say can be used in evidence, which means that there is a record, and for you to resile from your position at interview and say, well, I wish I hadn't said that because having thought about it, I wish I'd said this. Again, the court will say, or the traffic commissioner will say, well, hang on, no, this was your first account. In my opinion, this was your truest account. So that's really what's happening when you're under caution. So what you have to think about when you think about what the caution says is, what am I going to say and will it actually help me? And of course you do feel under a lot of pressure to assist, but you're not supposed to be assisting the DVSA and you're not supposed to be assisting the police, you're supposed to be helping yourself. Okay, so there's a difference between DVSA interviews and criminal police interviews. So the DVSA interviews, gathering evidence, and that's quite clear. So they stop your driver, they speak to your driver to establish whether they have committed a tachograph offence, for example. And therefore they need to have the elements of that offence proved so that they can do the fixed penalty notice or they can report for prosecution. But the other thing about a DVSA interview, which I think is the more insidious thing, is that they tend to be intelligence gathering. So they'll ask your driver at the side of the road about the particular offence, but you'll also see often that they'll have asked about, who do you work for? Are you self-employed? Does anybody else work from that yard? And all of that information, of course, has gone down and can be used in evidence. So that might then, what your driver says at the roadside, that intelligence may cause you to end up having a little knock on the door and a visit. So it's important that your drivers understand that, and it's also important that anybody working in your operation understands that there is an intelligence gathering element to the DVSA interviews, as well as just pure evidence for a potential offence or a breach. Of course, the other thing is that DVSA interviews straddle both the criminal proceedings because they can report you or they can give you fixed penalty notice, and also for the traffic commissioner. So that's the point of those interviews, is either criminal prosecution potentially or not at all. Maybe you satisfy them that there's nothing going on, or then equally for reporting to the traffic commissioner. Right. What people don't understand, and a question I often get asked is, I've been called for a DVSA interview. Do I have to go? No, you're not under arrest. You don't have to attend. Nothing can happen if you don't attend. Nobody's going to knock on your door and pick you up. And what I say to people is, ask yourself, if I go to this interview, will I help myself? Or will I just row myself into a lot of trouble and not give the investigating authority the trouble of rowing me into trouble as such? Am I going to be charged with an offence, and am I going to be called to PI regardless anyway? Does it matter what I say? Is the ball so far down the pitch that anything I do say is not going to make any difference? Because remember, what you do say will be evidence. Have you already spoken informally to the DVSA? So many times I see this, that you've had a visit to the office and you've chatted through everything, they've taken away records, and then they say, well, we'd like to interview you under caution. Well, the question there is, why? You've already cooperated. They will already have had a record of what you have said at that when they come to your offices. So why? It's not like you haven't cooperated. It's just pointless. They obviously, from their point of view, which is perfectly right, they would like it down in a formal interview under caution. But do you have to? Do you have anything more to say? Or you might have given responses in a letter when you've been asked for responses. You might have done it already. You've got nothing else to say. The other thing that you might want to think about is, are the DVSA talking to someone else? Is this a case of where they think licences are being run illegally? What will somebody else say? Have they talked to your ex-transport manager? What do you think your ex-transport manager will say? Will they say something different from you? So it's important when you decide to attend the DVSA interview to work out not what the DVSA want from it, but what do you want to achieve from it before you make that decision. And of course, we'd be happy to advise you. Okay, so preparing, we do attend DVSA interviews. I'm attending 2 days of DVSA interviews next week, so it's not don't attend. But preparation is everything. Find out what the questioning will cover. You're entitled to know what the case is against you. And what happens for lay clients is they don't want to do that because they're afraid that if they kick the bucket, it will look, and say like, what's in there, that it will look like they've done something wrong. But you are entitled to know what you're going to question me about, particularly what criminal offences potentially do you think I might have committed? And when you get that information, you've got to ask yourself, well, do I have a defence in law? And if I do, what is that defence? And also, how am I going to evidence that defence? Do I have evidence that will support what my defence is? For DVSA interviews, very often you don't have a defence, like you're banged to rights. But you might have a good explanation of why things went wrong. And it's important, and it's a good opportunity to put that forward in a DVSA interview. Because remember, anything you say may be evidence. So if you've made massive improvements and can substantiate that since whatever bad thing happened, it could be that it is really worthwhile going to the DVSA investigation, because it will go to a team manager who will say, actually, do you know what? I'm happy enough that this doesn't need to be upscaled to the Office of the Traffic Commissioner. But if you've provided documents, if you've been asked for documents, so many times I go to see people and they've given the DVSA a big old Tesco bag full of documents, and I'm like, yeah, can I see them? No, we didn't take any copies. Very difficult then to prepare the case against you. Well, what was in all that big Tesco bag? Can't really remember. So difficult to prepare. Prepare your answers. Yeah, if you know what they're going to be asking you about, you know your business, you know where the issues are, think about why do they want to know this? What kind of questions will they ask? And as I've said earlier, provide evidence to support your answers. If you are saying, look, since then we've done this driver went off on a frolic of his own and we fired him, provide documentation. At the end of every interview, whether it's a criminal interview or a DVSA interview, they ought to say to you, do you have anything else to add? Normally in criminal proceedings or criminal interviews, if anybody says anything at that stage, I kick them under the table, yeah? Because it's normally just tripe that won't help them. However, for DVSA interviews, what's a good idea is if you have made substantial improvements, that you actually almost have a spiel that you read out. Yes, I do have something to say. We regret that this has happened, or blah, blah, and we've done this and we've done that, and we're going to do this in future. So it's a really good way, evidence, again, which can help you. So it's worth thinking about. So in the interview, as I started, it's not your job to assist the investigation. You may choose to assist the investigation. It may help you to assist the investigation, but that is not the starting point. Sole purpose is for you to help yourself. If you've passed a document that you haven't seen before, ask for a break to see it, because when you think about it, it's likely going to be some sort of a taco record, or maybe it might be an invoice, it might be a fuel payment, it might go back 6 months. Well, if I asked all of you, where were you 6 months ago? You'd be like, I can't really remember. But if you're caught on the hop, you might answer something which later driving home you think, oh God, that's wrong, that's completely wrong. But then you've already given the evidence and now you're on the back foot, because now you have to say, oh, by the way, what I said to you was wrong. And of course, it may be genuinely wrong, but it could be interpreted as, oh, I regret I said that and I wish I'd said this. So if you're given something that you haven't seen before, even if it's a document that you handed in, but you haven't seen it for like 6 weeks, say, look, I need to have a think about this. Can we stop? You are entitled to stop the interview at any time you wish. Okay, similarly, if new matters are raised, or they say, yes, well, actually, since you've handed in these documents, this has come to our attention. Don't comment on it. Say to them, okay, I understand that. Can you please show me the evidence that you have that leads you to believe that this is the situation? Yeah. Don't, so think about it. Don't confuse evidence and supposition. So in an interview, whether it's a police interview or a DVSA interview, there's a difference between this is what we have to prove that this happened, rather than what we infer from all of this is that probably this operation has been loaning out its licenses. That's very different, an inference from actually having evidence. Don't comment on inferences. Don't just say, where's your evidence? And again, same thing, resist fishing expeditions. Do you want me to tell me all about your organisation? Tell me how you run your business. So how many people are working out of that yard? So Mr. X owns your yard and he also owns Mr. Y's yard. And Mr. X has no licence? Fishing expedition. I'm sorry, I can't comment on any of those things. I'm very happy to answer any questions relating to what you told me about before. So, one final thing before I move on. If you are entitled to, it's called disclosure, the information that they're going to ask you questions about. If you have a solicitor involved, it's more likely that you'll get the disclosure in advance. So the DVSA have been very helpful to me for the interviews I'm doing next week. They've provided me with all the documents they're going to ask my clients about. I've agreed with them like where the areas they are going. So my client is very well prepared. We spent a whole day the other day going through what we're going to do. If you go on your own, you'll probably only get an overview of the information and you'll probably only get it on the day. So there is a benefit of instructing a solicitor. Okay, the difference between criminal proceedings and PI. So there's a subtle difference. Criminal matters are evidence-based, yeah, they're adversarial. The prosecution must prove its case beyond reasonable doubt, and that includes at the police station. And there are rules of evidence which must be adhered to. Public inquiry proceedings are what we call inquisitorial. The point is to get to the truth. and any evidence, hearsay, inference, implication, is all okay. It might have different weights attached to it, but it's all okay. So there is more pressure on you if you're going to PI to assist in getting to the truth, so therefore to assist at the DVSA interview. And the way that you may assist is by putting forward mitigation where there's no defence. So even though you can't help yourself, you put forward your mitigation. Yeah, it all went wrong, this is the reason why. And as I said earlier, the DVSA interviews can be a mix of criminal proceedings potentially and also regulatory proceedings. Your options in the DVSA interview and in any interview, as you probably know from watching telly, is no comment. And no comment doesn't mean I did it, but I'm not going to tell you. No comment actually is just neutral. It's called putting the prosecution to proof. So in other words, I may have done it, I may not have done it, but I want to see your proof. Very important in criminal proceedings, but because DVSA investigations are different, inquisitorial to a degree, it's probably no point in doing that. If you're not going to give an account, just don't turn up. There is no downside of not turning up. You can't be arrested or anything like that. Answer questions. Remember, anything you can say could be used in evidence. So again, preparation. What are they going to ask me about? What documents have I given them? What answers am I going to give? Can I show any improvements? Do I have any defences? Prepared statement. Prepared statement is the same as answering questions. It is evidence that will be used. There's no requirement that you actually speak your answers in any interview. All you have to do is put down your account. And what a prepared statement is that you would potentially, if you felt that your client would be very undermined at interview, very tense at interview, you might say, look, we know the questions they're going to ask. So what we're going to do is go into the interview and we'll have you, we know they want the background to the business, they want to know this, and we would have it all down on paper and we would hand in the interview, the prepared statement. The interview would continue, but then you would answer no comment. Again, really with DVSA, I'm not sure that it's particularly good or particularly helpful, but it is an option that you would have, and I would definitely suggest that you don't decide that you do that on your own. You definitely need, because there are rules about whether it's a full enough account, etc. So don't just think, oh God, I went to this conference and she said just write it all down and give it to them. It's not as simple as that. Okay, so that's DVSA interviews. So now we're going to move to police interviews, which are a lot clearer in a way. A voluntary interview where you just agree to the police to turn up, they're unusual. A voluntary interview, you can leave at any time, but the chances are that if you leave at the juicy point, they'll just arrest you anyway. Okay, the police normally like to arrest you because it gives them some certain powers, including speculative search and taking DNA swabs. So when you're arrested, you'll have a swab taken from the inside of your mouth, and that swab will be run, the DNA from that, against a database of all unsolved cases. And it is possible to have your DNA removed from the database, but it's quite difficult. So it's that police like it. They have a huge database of DNA. It also allows them to do certain searches under PACE, etc. So under arrest, from the police's point of view, is actually quite a good thing. It's also quite a good thing from your point of view because you get the protection of PACE. The only thing that they're interested in, the police, is the criminal proceedings, so i.e. stuff that's going to go to the magistrate's court or the Crown Court for the more serious offences. Right. You are entitled to free legal advice at the police station. Doesn't matter whether you're the Queen of England or a pauper. You're entitled to free legal advice. Obviously at DVSA interview you're entitled to legal advice, but it won't be free. And you would be insane not to take up that offer, because anybody who gives advice at the police station not only has to be qualified as a solicitor, if it is a solicitor, but they also have to do separate examinations which make them specialist in police station advice. So it is a good thing to do. And that's why I say ensure your solicitor has the appropriate police station qualifications, because if you're just dealing with a transport lawyer, they may not have come through a background like Carolyn and I have from criminal defence work, where we have all the extra qualifications, which were very hard earned. So your transport lawyer may not be the right person if they also don't have the criminal background. Also, so just be careful about that. Now, what we found is that, you know, we're talking about really serious incidents, maybe a fatal accident or something, and that your driver may not be interviewed at the time of the incident because the crash reports aren't back in, the autopsy isn't back in to make sure that, you know, whatever happened was to provide evidence. So that is good because it gives you time to prepare. But what I have seen is a number of cases where actually it didn't really matter what happened in the interview, because at the roadside, the person who was stopped at the roadside made what's called significant statements. So it's terrible, it's dreadful, it's happened. Oh my God, I can't believe I've done this, I fell asleep. Bingo, that's the end of that. Because that's a significant statement and you'll be asked to sign it. Your driver won't know that they shouldn't sign it and they shouldn't blab and blurt. They'll do it, yeah? So be very careful about any informal statements to the police, yeah, because they can be used as evidence. So this here is just about the crossover between driver, criminal liability and that of director and company. So Robert Bradbury was a driver and he killed a cyclist in Birmingham and he was charged with death by dangerous driving. Now the reason that he was charged by death by dangerous driving was that he had a tray on the front where he kept his sat-nav and things, and it blocked his view, and if he hadn't got that tray he would have seen as he turned, he would have seen the cyclist in front of him. And he ran a defence. He was charged with dangerous driving first of all, and also death by dangerous driving, and then death by careless driving. And his defence was that he did not fall far below the standard of the competent driver, and neither did he just fall below the standard. However, it became clear that at MOT they had removed the tray because they knew that it would be an MOT fail. Yeah. So therefore, did his standard drop? Yes, it did, because he put his vehicle in a position where it was not safe anymore, because the vehicle can also be unsafe. But what he told the police at the roadside was, oh, I didn't think this was a problem. My gaffer has one of these. He said it was okay. Signed it, significant statement. Now it's not just the driver in trouble. Now it's the company. And the company, S&J Transport, were charged with an offence of aiding, abetting, counselling and procuring dangerous driving. So in other words, by knowing that he had the table and by not removing it and making sure he removed it, they were aiding and abetting it. And obviously I've put down there, you need separate representation in that situation, because presumably, I don't know, S&J would be saying, look, we never agreed to this. But that was a roadside statement which rode the company into it. So remember, it's not just your drivers. Preparing for a police interview. If you're under arrest, you can't leave. It's more difficult to get disclosure before the time of the interview. The DVSA are very helpful. They want it to move along. The police will be, no, we'll tell you when we're ready for interview and this is the disclosure that we'll give you. If you go in on your own, you will get much less disclosure than a solicitor will get, because the police actually don't have to give you very much disclosure, but there are some case law that says if they don't give you disclosure, then there are issues around that. Like I say, if the interview is not on the day of the incident, start getting your own evidence together. You know what it's going to be about. So this one, unlike the DVSA, where there's this kind of element of try and get my mitigation in because I want to show that I've assisted, etc. No requirement. It's all adversarial. What evidence have you got? I'm not going to provide evidence. I will comment if I want to on the evidence that you put before me, but I'm not going to start assisting. Do you have a defence, or is it just an explanation of what went wrong? It's only a defence that you need to put forward, because remember, it only harms you if you have a defence and you don't put it forward at interview. this idea of mitigation, I'm sorry this happened, doesn't matter. It's adversarial proceedings, so the police will still charge you no matter how sorry you are, or what changes you've made, because you'll have met the criminal standard. Here, no comment. Yes, here where is a no comment interview, you would do one, because if you have no defence, then that's the only option, because the only thing the police are interested in is, here's the evidence, do you have a defence? If you don't have a defence, then it will charge. Now there is this, I'm not going to go into it, where it might assist you if it was a cautionable offence, but we won't talk about that. Also, where you'd go no comment is, and this sometimes happens, where there's no real evidence yet. So something has happened, but they're waiting on the reports, but they want your driver to give what they call a first account. So you were driving down the M25. What happened next? No. There's no evidence at that point, so you don't want to create evidence. Yep. Answer questions. Only if you have a watertight defence and will be good under pressure. I think that stands for itself. Yeah, it's very intimidating, and make sure you actually have a defence. Prepared statement. Now here, a prepared statement is a good option because you have disclosure, you are answering what you want to put forward in your defence, nothing else. And as long as it covers all the elements of your defence, then it's as good as giving an interview, and you can't be harmed later by the fact that you gave in a prepared statement. What happens after interview? Well, the DVS, it refers to the DVS lawyer regarding criminal prosecution, or to DVS manager to decide whether it should be upscaled to prosecution, or the Office of the Traffic Commissioner. After police interview, you can be released under investigation, which is open-ended. They just say, we'll get back in touch with you. And there's a lot of outcry about that now, because there's some people who've been under investigation for over 2 years. If they release you on bail, then they have 28 days in which to bring you back. You could be told that there's no further action. In other words, you've put forward a defence, they accept the defence, they know that they cannot prove the case to the criminal burden, and there's no further action. Charged or given a court date, or you could be given possible bail conditions. You might also not be charged at that point. You could actually end up getting what they call a requisition, which is a charge through the post. But you'll have a fair idea, and if you have a solicitor, the solicitor will find out from the police what's going to happen. So, conclusion, think before you agree to attend a DVSA interview. If you're going to attend, contact the DVSA for disclosure. Get your own evidence together. It's no point in going and saying, oh yeah, I do loads of walk-around checks. Where are the proof of them? Stop the interview if you need to think about something, and consider legal representation. Police interview, get legal representation. And do not have any pre or post chats with the officer. So anything that you do say to the officer, he will take a note of quite properly in his notebook, and that can be used as evidence against you as well. So what people do is they behave beautifully, as I call it, an interview, and then I leave the police station, and the next thing is, oh, the officer, I spoke to the officer and I explained to him, I'm like, I told you not to do that. So I hope that has given you some food for thought, and you now realise what all of these interviews are that you potentially might be invited to. Thank you very much. No questions.